I suspect that may be something related to my client, that being his first name, but if there is one link to be able to have him admitted, that should suffice. I suspect that may be something related to my client.
Okay, well, let me let him in under the Joshua Adjei. Is it pronounced Adjei?
Adjei.
Adjei, okay. Good afternoon, Mr. Adjei. Can you hear me?
Sir.
Mr. Adjei, are you also trying to connect through an iPhone?
No, sir.
Okay. Well, I'll leave the entry that says Joseph's iPhone in the waiting room. If anyone gets word that that's someone who needs to be a participant, I'll move that person in. Again, there is a live YouTube feed of this for anyone who is interested in listening and watching as if you were here in court, where I am in courtroom 1D. So let's get started. Let me tell you all what I understand we're doing today, and then I'll give both the lawyers an opportunity to help provide the setting, excuse me, and then we'll turn to Mr. Smith as counsel for petitioner. So as I understand it, Mr. Adjei was with the DeKalb County Sheriff's Office through 2017 or so. And there was an incident that involved an inmate who got away from then officer. Was that your title? Was it Officer Adjei?
Yeah, officer or deputy.
Okay, well, we'll say deputy. That makes me think more sheriff than police. So Deputy Adjei, I think, was moving two inmates around in the jail, and one of them ran off. And the allegation is that Deputy Adjei didn't really move with a lot of urgency to track this guy down. And when ultimately this guy was re-detained, Deputy Adjei, with too much force, mishandled the gentleman, pushed him up against like the elevator wall, something like that. That's not what we're here to litigate. That incident ultimately resulted in Deputy Adjei no longer being a deputy. And more pertinent to what we're working through, it prompted Post to take away or to revoke Mr. Adjei's law enforcement certification, which is what's being challenged here. And I've learned a lot by reading the record here. I didn't realize how many steps are involved. So there was a probable cause committee that said the certification should be taken away. Mr. Adjei challenged that. And Mr. Smith, were you counsel throughout all this, or did you only come in for purposes of this appeal?
I came in right at the point of the action going before the administrative law judge.
Okay, well, that's where I was about to get. So there was an administrative law judge, or an OSA review, and that judge agreed that there was sufficient evidence to merit a sanction, but decided that the revocation was too harsh a sanction, and instead suspended Mr. Adjei's certificate for 6 months. That was challenged and went to Post, which has the final say until you get into the courts. And Post undid what the ALJ did. It said actually there was a basis for it, and revocation of certification is the proper outcome for a bunch of reasons. That's an outcome, understandably, that Mr. Adjei didn't like. And so Mr. Smith has petitioned to get the matter before me. My scope of review, and this is more for you, Mr. Adjei, to understand, is pretty limited. I will certainly listen to everything Mr. Smith and Ms. Radley have to say, but I don't get to find new facts. The record is the record, and if I am convinced that there was any evidence to support what Post did, I'm constrained to go with that. So what I don't do is reevaluate if what I think it was a Lieutenant Calhoun, but there was a Calhoun who had a lot to say, and it's not my role to say what Calhoun had to say was particularly compelling or not compelling. It was, Lieutenant. But Mr. Smith has identified a couple areas that he thinks are appropriate bases for appeal, and I will certainly listen to him about that, and then I'll hear from Ms. Radley about that. I will not rule from the bench. I'll enter a written order letting you know, Mr. Adjei, what I'm doing in terms of the appeal from Post's ruling. So, as I said at the outset, Mr. Smith and Ms. Radley, that's my sense of what got us here and what's going on. I know there's much more detail behind it all, but if I've missed something or procedurally I'm mistaken as to where we are, now would be a real helpful time to tell me so that I am in the right place to accept the arguments you're going to make.
Your Honor, I believe you gave a good rendition of where we are. I don't believe that Attorney Radley and I disagree on the procedures involved in the case, only the merit of the actual facts. And even with requesting it or argument, of course, I don't know what Post was going to argue when we had to request that as part of the petition. And so I really don't have too much to say other than what is actually already in our petition. Yes, the court is constrained by what they can do if there's by that any evidence standard, but under 50-1319 subsection H, in those paragraphs 1, 5, and 6, as alleged in the petition, is what we are looking at. And the court at that point, and looking at that evidence, can make determinations as to whether there was some rational basis for the decision made by Post in their final determination, which is different from the determination that was made by the administrative law judge.
So I'm going to pause you for a sec. I agree you've identified three bases under 50-1319. And I think they all tie together through this theme that Post, from your perspective, Mr. Smith, improperly considered evidence of acts of dishonesty by your client when what was before them was merely the excessive use of force, unlawful use of force, the too much force. And as I understand your argument, the sort of the due process angle to this would be Mr. Adjei was on notice that he was at risk of losing his certification because of the use of force, the excessive force incident involving this inmate that I described who sort of got away, always within the confines of the jail. As opposed to sort of a cumulative effect of, well, not only did you do this, but look at all these other things. And I have explored the other incidents, using his phone, not using his phone. Was he looking at the screen of his phone and having other issues? And I don't know if it's a long disciplinary history or a short one. I haven't had DeKalb deputies in front of me before, but put simply, there were other bases for Post to say, look, it's just, this isn't the right career for Mr. Adjei. Look at all these different things, culminating in the excessive use of force. Is that a fair summary that the main point you're making is Post got it wrong when they layered into their reasoning, there were also acts of dishonesty beyond the use of force incident?
That is correct, Your Honor. The other element of that, which is related, and it's admittedly a thin line that you have to kind of tip on, which is that in the presentation of evidence, that the evidence that was submitted at the administrative law hearing is different from the findings of fact that Post made in their independent investigation and what they based their final determination on. So it's those two principles that we are arguing.
Does Post in that final hearing have the ability to receive new evidence, or when is the record closed in a series of challenges to a discipline that is meted out?
What I was going to say, Attorney Radley probably has more experience with that than I do. But it is my understanding that once we were at the OSHA hearing, that we was precluded at that point. I am given or granted the opportunity to be heard at the final determination hearing that Post had, but at that point, I'm not allowed to be able to then pop up new witnesses and relitigate the case.
Okay.
Your Honor,
And Ms. Radley, I'm not trying to keep you out of this.
No.
I'll give you a chance to weigh in on all of this. But on that particular point, what would you add in terms of when the record is sort of fixed, and so any reviewing body is limited to what's in the record?
Your Honor, there's no additional evidence that's presented to Post Counsel. Post Counsel was provided copies of everything that was presented at OSA, both the documents and all of the testimony. So they were able to listen to all of the officers. And Post's position in this case would be not so much that Post found different things, but that Post found additional things were testified to during the hearing that the ALJ did not mention in his findings that were pertinent from a law enforcement perspective. And Post's really overall thing is that this decision comes from a non-law enforcement perspective, whereas Post's decision comes from a law enforcement perspective. And I think that's the difference.
So at which level, and either one of you can answer this, at which level of the proceedings did Rodriguez and Frazier and Calhoun testify?
OSA.
Okay, so the probable cause committee, who gets in front of them? That's that first level where the recommendation was revoke, and then it was challenged and brought to OSA.
They're given all the documents from DeKalb. So the PCC was able to review his entire disciplinary history. That's where I got it when they handed the case over to me. It was part of his investigative file, is that as you can see on the case summary, they list that he had prior incidences of disciplinary history. Mm-hmm. They have copies of all of the documentation from that, not the witness's testimony, but the documentation from those, and they review those in making their decision.
So PCC is purely paper-based. No
Correct.
one is testifying in front of PCC. They issue their recommendation. And then here, Mr. Adjei challenged it. I don't like that outcome. In front of OSA, both you and Mr. Smith are able to call witnesses. And so the testimony I would have reviewed of Calhoun or Frazier or references to the testimony and Rodriguez, that was all testimony that the ALJ received.
Yes, correct.
Okay. All right. So then, Mr. Smith, back to what you're arguing about. Is your argument that if the ALJ chose not to consider it, then Post should not have? Or is your argument that, in fact, Post was considering things that were extra record, meaning outside the record of what the ALJ considered?
All right. So part of it is, my client not having exact notice as to all of these untruthfulness allegations. That's part of it. Then, as you have just been informed, there's a record that is created, and the recommendation initially from Post was based upon the written record. Now you have the individuals that comprise those complaints who are able to testify in court about specifically what happened. And in looking at that evidence, Post still stuck to their guns on some things, in my opinion at least, to some things that was in a written record that were different from what was testified in court. The untruthfulness issue, I believe that the administrative law judge considered all of those issues and did not find those issues per se to be compelling or one that notice was given to Mr. Adjei to be able to address that. And so it must not have been an important issue for Post.
Well, I want to separate those two. Not getting notice is something that I'll explore with Ms. Radley when it's her turn to go. But what does it matter that the ALJ may not have put much weight on the incidents of untruthfulness, since Post has the ability to effectively overrule that? Ms. Radley's observation that we've got an administrative law judge who is not law enforcement specialist and in a vacuum might say, this just doesn't seem so serious. But then you shift to the final decision and Post looking through a very different lens, and one might argue the more relevant lens because it's a law enforcement lens, says use of force, big problem, or excessive force, big problem, and these additional instances of dishonesty or untruthfulness, that seals the deal. Revocation, the original recommendation is actually correct. It's a long way of saying, what's wrong with Post overruling the ALJ? Isn't that Post's role, assuming Post is relying on evidence in the record? They just are filtering it through a different lens, and so unsurprisingly came up with a different result.
But that's where our argument with 50-1319H5 comes in. Clearly erroneous in view of the reliable, probative, and substantial evidence on the whole record. That believe that the live bodies testifying to these incidents should be given more weight than a written record, which doesn't have the opportunity in and of itself to be able to explain itself. And when you listen to the testimony paints a picture that is different from the picture that is being painted by Post.
Okay. I understand your argument. What else do you want to share? I hear you that basically your brief lays it out, but here we are with oral argument. Is there anything more? And you'll get a chance as the petitioner to have the last word after Ms. Radley weighs in for Post's perspective. But was there more you wanted to share, Mr. Smith?
No, Jan, I believe that, is a lot of information that is in the record. Obviously, you have written records, history, you have the audios of the testimony. So there's a lot of information, and I don't want to basically just regurgitate the same information that's in front of you. But I wanted to also make myself to be available if our view was unclear, which you have asked those questions to get clarity.
Okay, so I want to play back for you what I heard. Your two main arguments are Post improperly considered the incidents of untruthfulness. Those weren't properly before. And then it's sort of a corollary or related to that. By considering it, they were violating Mr. Adjei's due process notice rights because his perspective was always, I'm in the crosshairs because of this excessive force situation. And I will defend the excessive force situation. I didn't know I needed to defend against the dishonesty. That wasn't the incident that was before everyone. And so I didn't get an opportunity to try to explain to Post why Post ought not to weigh the dishonesty or the untruthfulness scenarios the way they did.
That's correct, Your Honor.
Okay. All right. Ms. Radley.
Yes, Your Honor. With regard to the due process, he was given the case summary, which indicates, one, that he had a use of force, but also that the issue surrounding the use of force, which he was well aware was the reason he was fired, because not only did Lieutenant Calhoun testify to it, but according to their rankings or whatnot at the DeKalb County Sheriff's Office, he was actually not recommended for termination as a result of the use of force. Lieutenant Calhoun testified, and it was in the documentation, that once he got look at all of the past history and looked at the use of force incident itself, because of the untruthfulness aspect of it and the fact that he demanded to see a video before he could write his report, that he chose, based upon his experience, I think he had over 20 years, he recommended him for termination because he felt that he was not a forthright and truthful officer. And
But
so
termination is different from losing your certification. So your point is Calhoun injected into the record, so now everyone's on notice. Hey, a real important factor for me, in other words, what put it beyond just a sanction to termination was excessive force plus these situations of untruthfulness.
yes, Your Honor.
Okay.
And within the case summary, it also listed the prior instances. And while PCC was able to see all of those prior incidences, of course, Your Honor is aware that once he contests it and it goes to OSA, that's where we have to present evidence. And that's honestly, Your Honor, where the biggest part of due process and notice comes in, because we present it to OSA and we say, these are what post issues are. And it did include those prior incidences with regard to Rodriguez and Frazier. Unfortunately, like every case, I couldn't get all of the witnesses to testify to every incidence of disciplinary action. I'm still amazed I was able to get people from back almost 10 years ago who not only remembered the incidences, but were willing to come in and testify. And before the court, through both the documentation, so from the very beginning, and at the court where Mr. Adjei had the ability to respond to the motion for summary determination and respond within an actual evidentiary hearing where he had the ability to see, hear, confront witnesses and put up witnesses of his own. He heard all three of them, and there were more witnesses, but the three main ones from the three disciplinary actions all testified that they did not trust him. They did not like working with him because they did not trust him. And that all three incidences involved elements of being not forthright and not truthful. And it, each in and of itself, other than the final one, because clearly law enforcement felt that it merited more than what their own documents would give you. But all three of them together, show a pattern of the kind of law enforcement officer that Post does not feel is appropriate to be certified. It's a person, certified law enforcement officers are held to a higher standard, and he didn't meet those standards according to Post.
Is it clear to you, or could you point me to where in Post's ruling, so the final ruling, they clarified that the dishonesty that they were relying on in part in overruling the ALJ and reinstating the decision that certification should be revoked, that the dishonesty they were relying on was more than the dishonesty that sort of infuses the excessive force incident. And Mr. Smith and the ALJ made a fair amount about how I think Lieutenant Calhoun, I don't remember exactly how he described it, but he said it was less than clear, or he's basically being euphemistic, saying, hey, the first version of events that Mr. Adjei gave before he watched the video was effectively baloney. And then he watched the video and he said, whoa, I want to take back that first thing I said, because it didn't match the video. He was describing a different incident, or put differently, he was whitewashing his incident so that it sounded like it wasn't nearly as serious as it was. Then he saw the video and he realized, dang, if Calhoun's seen that, I've just lied to Calhoun. These are my words, not Mr. Adjei's. So I need to get that first statement withdrawn. That's dishonesty. And I could see Post saying that, coupled with the excessive force, is enough, certification revoked. And if that's the dishonesty they were relying on, I see much less of a due process issue, because everyone was focused on this incident. And so I'm not asking it real concisely, but if Post was also explicitly referring to the Rodriguez situation, the Frazier situation, that would help me with my analysis.
Well, in the initial case summary, the PCC recommendation says he was found in violation of performance of duty, neglect of duty, and use of force. With regard to the issuance of variance between the petitioner's statement submitted to Calhoun, the recommendation said, oh shoot, I just went past it. A review of the incident revealed that his report did not coincide with what was found in the video. Now, I agree, it's not the most artfully written case summaries, and I have, for lack of a better term, yelled at Post about their inartfully written case summaries. However, in addition to that, you have the fact that it does list out that they reviewed his prior history of 8 incidences, while only 3 were presented to OSA because, again, evidentiary issues. But you also have the fact that the PCC committee and council say what the reasons are, what sections of the Post Act. They don't just say he violated the Post Act. They say he violated it at A2, A6, A7, and A8. And 2, 6, and 8 are all in reference to lack of trustworthiness, deception, and misleading behavior, Your Honor. Whereas only subsection 7 is the one that goes to use of force because that's violating a rule, law, or regulation. So if Post was only concerned about the lack of force, they would have left it at 7. But they not only did 2, but they also did 6, and they also did 8. And so 2 is knowingly made misleading, deceptive, untrue, or fraudulent representations with regard to the practice of being an officer. 6 is engaged in unprofessional, unethical, deceptive, or deleterious conduct harmful to the public. And 7 is specifically committed an act or omission which is indicative of bad moral character or untrustworthiness. So, you know, I understand where Mr. Smith is coming from, and honestly, working on this case with him has been an absolute pleasure. He is one of the most professional attorneys I've dealt with in my 20 years of being a lawyer. But, you know, respectfully, Your Honor, it's in there. Post put him on notice 3 times over that the issue was the fact that, you know, he just doesn't ever, it's not so much that he lies, it's that he relies on semantics and mischaracterizes, and you cannot have, especially in this day and age, you cannot have a law enforcement officer who says, well, I want to watch the video before I write my report, and then it turns out that the 2 aren't the same. That just cannot happen. It cannot happen. Your video should maybe supplement, as in you forgot that the woman was wearing a skirt over top of her leggings, but it shouldn't be a complete thing of, nope, I wasn't on my phone. Nope, wasn't on my phone. Oh, okay, wait, I had my phone out, but I wasn't using my phone. Or, you know, his other thing of saying he didn't have his phone out while they were in court, and then they watch the video and he's on it for an hour. Your Honor, it just, in Post's mind, you can't do that. And then this was the 3rd one. And obviously the initial 2 weren't brought to Post's attention until he's terminated. But Post has a duty and an obligation when a person is terminated, or when that officer's conduct is brought before it, to review that officer as a whole and not just the one incident.
It would have been Rodriguez and Frazier who would have testified to the ALJ about the in-court cell phone usage and this situation with the cell phone and
yes,
unloading a van or having civilians move around a transport van or something.
Yes.
Okay.
And again, you know, even if you want to sort of move those aside, even if we're just talking about the December incident at the jail, again, you have Lieutenant Calhoun's testimony where he said, I got this, it came across my desk for review. He was recommended for a suspension of a certain number of hours. And based upon my review, I felt it merited termination. And the sheriff agreed, and then it was appealed, and Tolbert agreed as well. And so it was upheld throughout based upon not just the excessive use of force, but the coupling of how his report was inaccurate and had omissions, and it didn't jive, it didn't coincide, that's their word, didn't coincide with what was on the video. And in their mind, you know, they don't want a person who does that as a law enforcement officer.
So you cited to the subparagraphs 2, 6, 7, and 8 as the provisions that Post was saying Mr. Adjei's conduct had violated.
Yes, Your Honor.
Is there some document that Mr. Adjei is given at the different points in these proceedings, the PCC, as you call them, and then when it goes to OSA, that says, look, these are our bases? And it may just have those paragraph numbers. I'm not saying it's spelled out.
It does. The case summary. He's provided with a notice sent via certified mail that says, you're hereby noticed that the council met and decided to revoke your certification, and they attach and put the case summary with it. And on the case summary above the signatures of the council and PCC chair says which code sections it's with regard to.
And then the ALJ would have been given the same statutory citations that Post got to where we are, or the PCC got to where we are because of its finding that violating these provisions merited revocation of certification. And then the ALJ, in his wisdom, said, I hear you, but that sanction, given the record that was established before the ALJ, was deemed to be excessive.
Correct, Your Honor. Post viewpoint is that the ALJ did not, again, as you said, view it through a law enforcement lens and was purely looking at the use of force, as opposed to the fact that, you just can't have an officer who says, I need to see the video before I write my report. And then, I think he also, I'm pretty sure Calhoun testified that once he asked to see the report, he told him no, write up your report. He wrote it up. And then once he looked at the video, he actually asked to draw back the statement that he had made and do a new one. You can't do that. And Calhoun testified, you can't do that. And officers can't do that. You need, your memory is what it is, and you can't color it to make yourself look better, because we all know what happens when that happens.
Great. All right. Anything else you want to add in response to Mr. Smith's arguments today, or anything he's filed?
No, Your Honor, just the only bit of clarification is that Mr. Smith said that, relying on the live bodies is what's important. And again, I want to be clear that post-council, before they issued their final order, they did rely on the live bodies because they listened to the actual testimony. They had the CDs from OSA. And again, the post position would be, it's not so much that they discounted what the ALJ said, it's just that they supplemented it through the law enforcement lens.
Okay. And what's the status of, I guess this may be more a question for Mr. Smith, of Mr. Adjei right now? Because you've appealed this, does Mr. Adjei still enjoy his post certification? Or because post said it's revoked, and the hope would be that that decision is reversed?
He does not, because post said that is revoked is revoked. And so the suspension that was recommended by the ALJ does not take effect. The final determination of post is what controls.
Okay. Mr. Adjei, have you found another line of work for the meantime? What have you been up to?
Your Honor, I've been doing part-time jobs here and there, trying to get enough money to pay my bills. All agencies will not hire you if your post certification is under review. So for the past 3.5 years, I've been just doing various part-time jobs, trying to get various jobs to try to make ends meet. And I haven't been able to work at any agency, doing any kind of law enforcement work for any agency. And so that's what I've been doing for the past 3.5 years, waiting on this process.
Okay. Are you able to do security work? I appreciate there's a difference between law enforcement and security. And I don't know what your interests are. You may want to be a piano tuner if you're not going to be a police officer. But with your background, it would seem like you would be able to do security work. I don't think you have to be post-certified to handle some of those things.
Yes, I could do that. But number one, the pay is a lot less. And number two, all the security places that I've been applying for, most of them, I believe I've run into the problem of being overqualified. It's like most of them don't even give me a call back. And I'm not sure because I've been to 3 interviews in 3.5 years. And I put in applications at security places, at different places every single day. And I can't get a call back because I'm not sure if the fact that I have 25 years experience and a bachelor's degree in criminal justice, and they're looking at me as like, hey, we're only going to pay $12 an hour.
Right.
And
well, they're probably worried you'll figure out how to run the whole company, and then the managers will get fired. So who knows? Okay.
Yes, sir.
Well, I appreciate you sharing that. It's just helpful to hear a little bit about what's been going on. Well, Mr. Smith, I promised you could have the last word if there's anything you want to say in response to what Ms. Radley has shared. Anything you want to add, or are we good?
Just a couple of things, Your Honor. First, I'd like to thank her for the compliment. I think
that was a pretty good compliment.
Well, we have
Deserved it.
Yeah, we have the University of Virginia in common. So
there's some cavalier love here. All right.
It is. But we can pass that on to Judge Shoup as well. But I will point out to the court page 56 of the evidentiary file that was submitted to you by Post or by Ms. Radley. That contains at that very beginning the dismissal for Mr. Adjei from DeKalb County. And if you look at that, there's no mention of use of force there. And it's well and good to testify at a hearing that was part of the basis, but Mr. Adjei still wasn't on notice of what that basis was. The written documentation does not mention use of force when he was separated from DeKalb County.
Okay, you're now getting again above my skill level in this area of law enforcement appeals. Aren't we talking about two separate channels? DeKalb does what it does, rightly or wrongly, following HR protocols or not. Post is different. And DeKalb may have said, we fired you because your beard is too long. Right. And that may be not appropriate, and that's an issue for DeKalb. But Post has its own certifications and rules and regulations. And what I heard Ms. Radley saying is that it wasn't DeKalb County's notice that you were fired because, but it is the case summary that would come out of PCC saying, here is why we Post are doing what we're doing. I mean, I assume, I don't know this to be the case, that DeKalb could have said, you're employee of the year, we're keeping you here. And Post could have said, that's fascinating, but he doesn't have a certification anymore because what he did is inconsistent with the principles of trained law enforcement officers.
No, that is true.
Why I should be interested in what DeKalb County said when they separated Mr. Adjei.
We still go to the issue of notice. Okay. So DeKalb County didn't give him that notice when he was separated. If we look at the summary that Attorney Radley mentioned, that's at page 80. That begins at page 80 through 104 of the record that was tendered to you. When you go through there, it states under the case summary, specifically anything that deals with the truthfulness, it says, if I can find it here. A review of the incident revealed that Officer J.A.'s report of the incident did not coincide with what was seen on the video. And that's the only assumption of untruthfulness that we can make. So there's a header that says case summary, and it summarizes all of that information. That's at page 84. Then on page 85, there's just a header that lists disciplinary history. And for myself, in cases that I've handled dealing with Post before, if there's any disciplinary history of an officer is listed in that category, not necessarily that was used as a basis for a determination, but that's on page 85. And so that's where, from our viewpoint, the lack of notice kicks in prior to that revocation. Now, I will concede that once it went over to OSHA, there was a motion for summary determination that was filed by Post, and within that, there are now allegations that are related to untruthfulness, but prior to that, there is none.
So I'm going to pause you there because I'm looking at the record at what I think is page 85, and it's not lining up quite right. Ms. Radley, where I have a record that has 297 pages, but they're not Bates numbered. Those are just in the PDF. It's that many pages. How do I find this case summary? Mr. Smith said go to page 80. And it may be off a little bit because the first page is actually your notice of filing, and then there's a certificate of service. So I may need to add, looks like 6. So maybe let me go to 86 and see if that fixes it.
Try page 82, Your Honor. That's the certified notice. That's where it begins. The first part is the letter from Investigator Shaw with Post. That starts on page 80, and then the certified letter starts on 82, and then the summary starts on 84.
So I've got a page, for me, it's 85. It does say case summary, but above it, it's probable cause committee recommendation to counsel. Are we?
Yes, that's it, Your Honor.
Okay.
That's the case summary, and I can't remember whether it's 2 or 3 pages. That also has the code sections in it, and then it would be signed by the PCC chair and signed by counsel.
Okay, yeah, there's a Scott Moorer and Mike Yeager.
Yes.
So I'm looking at that, and it does, oh, okay, I found what I was looking for. Okay, thank you. So that's.
So, yeah, once that's done, Your Honor, that's the point when he chooses to appeal. They did discuss it at Post with a pre-hearing, but then it goes over to OSA, which is really sort of where it all begins with regard to evidence being contested, not contested. And immediately from the beginning, when this was filed at OSA, the motion for summary determination was filed from the very beginning. It's not like a motion for summary judgment where we sort of started the case and then I filed it later. It actually was filed at the very beginning when it went to OSA. So from the second it entered the doors of OSA, there was notice there as well that these are what the issues were. So it's not like it came up in the middle of the hearing that this is what the issues were going to be and they had to try to figure it out. I mean, they were told in the motion prior to the hearing that these were what the issues were for Post.
Okay. All right, that's helpful, both of you, to get me into the record. So I now see where the case summary starts and the listing of disciplinary history, and then the violation, there's the statutory reference that Ms. Radley mentioned. All right, Mr. Smith, did you have anything? I interrupted you. You were guiding me to different parts of the file.
Well, I just wanted to because I know it's 297 pages. You may not have a couple of hours, and your law clerk may not have a couple of hours to itemize that record. So I just wanted to try to help the process by pointing you directly to it.
Okay, I appreciate that. Anything else?
No, Your Honor.
All right. So I have one last question. When I was reading the ALJ's opinion, I was a little surprised at the way in which the ALJ seemed to disregard, I'll call it the law enforcement perspective that Post would have. But I haven't dealt with a lot of OSA matters. Usually when I'm dealing with ALJs, it's unemployment benefits, and that's their wheelhouse, and they know that stuff. But this ALJ seemed to be more of a generalist, and so was focused on general principles. But I'm curious, insofar as you, Ms. Radley, or you, Mr. Smith, work in this area of Post appeals, if this is a common occurrence that the case ping-pongs from Post saying, here's what ought to happen, and ALJ said, you crazy, and it goes back to Post saying, no, we're not crazy, you're the one who's crazy. Because poor Mr. Adjei and poor Post, I mean, they said, here's what ought to happen. ALJ pulls it over here, and then it goes back to Post, where Post, unsurprisingly, says, well, no, actually, what we said before is really what ought to happen.
To my knowledge, well, I've been at the AG's office 7 years. This is the first. Prior to that, I want to say a couple years before that, there was one other case where it happened. It may have happened, 1 or 2 other times, but I want to say within the last, 15 years, it's only happened a handful of times, Your Honor.
And to be clear, I don't expect ALJs to be rubber stamps. That wasn't my point at all.
Yeah.
It just,
No.
as I processed this, it seemed, and judges sometimes need to do this, but it was sort of substitution of judgment. It's a different form of appellate review. I get to do appellate review very infrequently, and it is 9 times out of 10 in this extremely confined, you may not make any factual findings. I'm sort of stuck with the record. And I may say, it's so clear that guy was lying, I can't do anything about it. Because if the entity below me said, but we believe the guy who was lying, I'm stuck.
Right. It is definitely an interesting area because it really does not happen very often. And like you said, this isn't where a post, came back in and said, well, no, judge, you got it all wrong. It's more of a, well, we see what you found, but you neglected to look at these other things that were also in the record. Like you said, it's the different lens. And so I think that varies. I will say I looked back through and I had not seen where this particular judge had ever had a post case before. But, it really has only happened a handful of times.
Well, Mr. Smith, you must have been feeling pretty darn good then after you got the results from the ALJ.
Well, I felt good walking out, but I will say, there's not too many attorneys that do a fair amount of practice dealing with post cases. I've kind of gotten a first name basis around there.
Yeah.
But even in the cases that I handle very frequently, has it had to go even to the point of OSHA. But I do a lot of law officer related matters. I'm a former prosecutor for the city of Lithonia. I teach police and law enforcement at Morehouse. So I have a kind of a relationship with individuals in that community, but it's not a typical case that would have reached this level.
Sure. Well, Mr. Adjei shopped wisely for counsel. Mr. Adjei, like I mentioned, I am not going to rule from here. I need to get back into that 280-page record and poke around a little bit and do some research. I will issue a written order. And whatever that order is, I wish you the best in your future endeavors, whether you're back in law enforcement or it's going to be piano tuning or being a doctor or whatever it is you decide you do. I hope that that goes well for you.
Thank you.
So, Mr. Smith, anything else other than I'll get you in order when I'm able?
No, Your Honor.
Ms. Radley?
No, sir.
Okay, well, thank you everyone for dialing in. Be safe, and we'll